War is not a blank canvas. Every act, every decision, every order carries consequences that echo far beyond the battlefield. But in the fog of conflict, accountability is often murky, delayed, or denied. So, when does an act of war become a crime? When does a commander, a politician, or even a whole state become legally responsible for atrocities? These questions sit at the very heart of international law, a framework designed to restrain the chaos of war, to impose morality on power, and to ensure that human dignity is never just collateral damage. Before we dive in, consider this. While history celebrates victories and strategic brilliance, it also hides a darker ledger of failures, abuses, and legal loopholes. The courts that have tried war criminals, the treaties that promise accountability, and the principles that define justice aren't just abstract ideas. They affect real lives, real victims, and the moral compass of entire nations. The modern concept of international criminal law was born from catastrophe. The Nuremberg Trials, held after World War II, were a true watershed moment. For the very first time in history, individuals were held criminally accountable for actions they took as part of state policy. Military leaders, politicians, and bureaucrats faced charges of crimes against peace, war crimes, and the newly defined crimes against humanity. The trials established a groundbreaking principle: simply following orders is not an absolute defense. Legal responsibility transcends nationality, rank, and context. But Nuremberg also revealed critical limitations. Only the defeated powers were tried, leaving the victors largely immune to scrutiny. Political considerations often dictated who faced justice, and the scope of what could be prosecuted was heavily debated and restricted. Critics raised valid concerns about victors' justice and selective enforcement. Still, the trials set an undeniable precedent. The world acknowledged that some acts are so heinous that accountability must be universal. Decades later, the International Criminal Court, or ICC, was established to provide a permanent forum for prosecuting genocide, war crimes, and crimes against humanity. Unlike the temporary tribunals that came before it, the ICC aims to apply the law consistently, independent of shifting political winds. Its very existence signals a global commitment to restraint and ethical oversight. Yet it too faces enormous challenges. Jurisdictional limits, a lack of cooperation from powerful states, and intense political pressures all complicate its work, highlighting the constant tension between legal ideals and geopolitical realities. Responsibility under international law isn't just for the person pulling the trigger. Commanders and leaders can be prosecuted for ordering crimes, authorizing them, or even just failing to prevent them. Civilian policymakers, military planners, and even corporations providing logistical or financial support can all fall under scrutiny. This is the principle of command responsibility, and it ensures that authority carries real legal and moral weight, not just operational control. Think about the case of Rwanda in 1994. The genocide against the Tutsi population resulted in the deaths of an estimated 800,000 people in just 100 days. International tribunals prosecuted the key architects of this violence, firmly establishing that orchestrating mass murder cannot be shielded by national borders or political office. But these prosecutions also exposed the international community's tragic failure to prevent the atrocities in the first place, highlighting the difficult ethical tension between intervention, state sovereignty, and the responsibility to protect. Eyewitness testimonies, survivor accounts, and documentary evidence are central to proving these crimes. They provide the human context behind dry legal definitions, illustrating the intent, the impact, and the culpability. Prosecutors rely on these powerful accounts to build their cases, connecting the orders given in a command center to the suffering that occurred on the ground, demonstrating that behind every statistic lies a human story that demands recognition and justice. Yet, these legal proceedings are agonizingly slow, often taking years or even decades to conclude. This delay raises profound ethical questions. How can survivors find closure with such delayed justice? How does a society rebuild when accountability lags so far behind the atrocities themselves? These gaps in time complicate reconciliation and healing, but they don't negate the absolute necessity of legal intervention. International law also grapples with the limits of enforcement. Powerful nations can resist prosecution, shield their leaders, or use their influence to sway legal proceedings. Some argue that national sovereignty should always come first, while others insist that morality cannot be subordinate to politics. This constant tug-of-war between law and power underscores the fragility of our global justice systems. Adding another layer to this is the concept of universal jurisdiction. Some states assert the right to prosecute certain heinous crimes, like genocide or torture, regardless of where they occurred or the nationality of the perpetrators. This principle reflects a global understanding that some acts are offenses against all of humanity. While enforcement remains politically complex, the principle itself reinforces the ethical foundation of international law. Some acts are simply intolerable, everywhere and always. Case studies bring these nuances into sharp focus. After the brutal conflicts in the Balkans, the International Criminal Tribunal for the former Yugoslavia was established. It prosecuted leaders for ethnic cleansing, mass murder, and forced deportation, demonstrating that legal frameworks could adapt to new and horrifying contexts. More recently, corporate responsibility in conflict has emerged as a new legal and ethical frontier. Companies that supply weapons, logistical support, or financial backing to warring parties may face scrutiny if their actions contribute to atrocities. This expands the scope of accountability beyond just soldiers and politicians, embedding ethical considerations into economic and operational decisions. Education plays a critical role in reinforcing all of this. Law schools and human rights programs ensure that future leaders understand the ethical and legal constraints of power. Knowledge of past prosecutions and survivor testimonies equips policymakers to act more responsibly, reducing the risk of repeating history's darkest chapters. At the center of it all are the survivors' voices. Courts increasingly recognize that legal documents are incomplete without human testimony. Memory, emotion, and personal narrative are what transform abstract legal principles into tangible moral imperatives. Justice isn't just about punishment, it's about recognition, validation, and a society's acknowledgement of the harm that was done. Even the prosecution's strategy is filled with ethical dilemmas. Deciding who to indict, which crimes to prioritize, and how to balance national reconciliation with legal rigor are all incredibly complex choices. Prosecutors must navigate political, cultural, and humanitarian considerations, proving that law is practiced in the real world, not just in theory. The moral impact of international law extends far beyond the courtroom. Public awareness, media coverage, and educational outreach amplify the lessons learned from these prosecutions. They reinforce norms against atrocities, shape global expectations, and create pressure for responsible governance. Even a failed prosecution can carry ethical weight, sending a clear signal that impunity is unacceptable. Despite all its limitations, the pursuit of justice matters. Legal accountability validates the suffering of survivors, helps deter future crimes, and upholds essential global norms. It embodies the principle that human dignity transcends national borders and political convenience. By holding perpetrators accountable, societies reinforce their own ethical standards and contribute to a world where war does not excuse impunity. Ultimately, international law challenges us to confront uncomfortable truths about how power, politics, and strategy intersect with ethics, morality, and human rights. The legal frameworks provide guidance, but they rely on commitment, courage, and global cooperation to be effective. Justice is a process, often imperfect, always challenging, but its pursuit shapes the moral landscape of nations and the lives of millions. The lesson is profound. Wars are fought not only on battlefields, but in courtrooms, classrooms, and in the public conscience. Responsibility is universal, and the pursuit of accountability is our best defense against repeating the horrors of the past. Thanks for joining us on this deep dive. If you want to explore more about the intricate relationship between war, ethics, and law, be sure to subscribe to our channel. Your support helps us continue to create content that informs, engages, and challenges us all. We'll see you in the next one.